Today, I want to talk about operating agreements, what they are and when you need them. So, an operating agreement is a document that is prepared that governs the ownership and operations of limited liability companies. So, they're not to be used for corporations. Corporations, if you're going to have something similar to that in the corporation realm, it's going to be a shareholder agreement or bylaws. But for limited liability companies, it's going to be an operating agreement. And so when do you need it? So there's a couple of scenarios when you need it. So the first is if you are forming your LLC in a state that has anonymity. So the two common states are Wyoming and Delaware. They both provide for anonymity. So in those states, um, you're filing basically a one-page document with the Secretary of State of those states. And it basically says, here is the name of the LLC. Here is the statutory agent. So this is the person that's authorized to receive service of process within the state of formation. And you have to have that. And the limited liability company is either member managed or manager managed. And that's it. That's it. And that's what you file with the state of formation in Delaware and Wyoming. Well, then that's great. But how do you know who owns the company? Because the records of the state of formation do not tell you who the owners of the company are. So in order for you to know the owners of the company, you have to have an operating agreement. And because these states offer anonymity, their statutes provide that you have to have an operating agreement. So for you to validly form a limited liability company in a state that has this anonymity, the statutes of that state require that when you form, you have a signed operating agreement that lays out the ownership of the company, the management structure of the company, and sets forth everything that the company needs as far as its operations. That's not the same in Arizona, for example, where we don't have anonymity. So when you form in Arizona, you file and you specify in Arizona who the owners of the company are, meaning the members, and you specify that. And by default, it's percentage based upon the number of members. So if you have 2 members, each is going to own 50% of the company. If you have 3 members, each is going to own 1/3. Or if it's just one member, then that member owns 100% of the company by default. And then you specify who the managers are. And if it's a manager managed LLC. And so you then identify here are the managers. And our statutes in Arizona provide that the managers have certain powers, duties, and obligations. You don't need an operating agreement to explain that. So in Arizona, for example, if I go and form an LLC and I'm the only member of the LLC and I'm the only manager, if it's a manager managed LLC, in that case, I don't need an operating agreement because the statutes dictate everything from ownership to management and operations. The statutes basically become the operating agreement. I don't need to, go through the process of having this other document out there. Nor is it needed for asset protection. We have cases in Arizona that say, hey, you don't have to have an operating agreement in order to create the corporate veil and to protect the limited liability company from having the corporate veil pierced. So you don't need it in that case. However, let's say that you have 3 members, but 2 of the members are going to own 40% and the other third member is going to only be 20%. Well, then in that case, you're definitely going to want an operating agreement because you're going to want to specify that different ownership percentage versus when you file with the Corporation Commission, like I said before, the default is 1/3. So if you don't have an operating agreement, you file the articles of organization, then the presumption is everybody owns 1/3. You have to have that separate operating agreement that states otherwise. So that's the situation or the scenario where you're generally going to want to have an operating agreement. Or let's say that you have two members, two owners of the LLC, but you have capital contributions that one member is making, and the expectation is that there's going to be an event that's going to happen. For example, the sale of real estate. So, let's say this LLC owns 3 pieces of real estate, and you have one member that's put in capital to purchase, each of those properties. So, every time a property is purchased, you have a member that comes in and puts in capital for that. And you want to make sure that if you sell one of those pieces of real estate, that member who put in the capital for that specific purchase, that they receive their money back. In that case, you're going to want to have an operating agreement that specifies when that capital is going to be returned, because otherwise, by statute, the capital is just returned upon dissolution. Or agreement of the members. So you're going to want to have an operating agreement that specifies the early return of capital. So that's when you need an operating agreement. And those are the scenarios that really an operating agreement comes into play.